Tom Edens had been the ditch rider on the Pinto Valley Canal for 31 years, and on the morning this started, he was doing what he'd done 10,000 mornings before, walking the main ditch with a shovel over his shoulder, checking the head gates in Catron County, New Mexico, in the dry spring of 2018. He didn't know he was watching the beginning of anything. He'd tell you so himself. He just noticed that the Vance headgate was shut and chained, and that the chain was new, and that there was a sign on it with a mining company's name. He stood and looked at it a long while. Then he went and found Della Vance, because somebody had to tell her that her water was gone, and it had better be a man she knew. This one almost didn't get told. Somebody had to write it down the way Tom eventually did, or it would have gone the way most of these go, quietly in favor of the people with the lawyers. If you believe a story like this deserves to be remembered, take a second and subscribe before we go any further. The rest of it matters. Catron County is the emptiest county in New Mexico, and one of the emptiest in the country. It's high, dry mountain and mesa country down near the Arizona line. More elk than people. The kind of place where the distance between neighbors is measured in miles, and the distance between towns in tanks of gas. Water out there isn't a utility. It's the whole question. Everything that lives in that country lives because somebody, a long time ago, figured out how to move a little water to it and hold on to the right to keep moving it. The Pinto Valley Canal had been carrying snowmelt down out of the high country to a string of small ranches since before New Mexico was a state, and Della Vance's place sat near the bottom of it. 400 acres of hay meadow and pasture that her family had watered off that ditch for 110 years. The mining company was called Cordillera Resources, and they'd come into the Upper Valley 2 years before to reopen an old copper prospect. They needed water. Mines need a great deal of it. And they'd done what well-funded companies do. They'd bought up senior-looking water rights from a couple of ranches that were selling out. They'd hired a water lawyer from Albuquerque, and they'd filed with the state engineer to consolidate and move those rights upstream to the mine. On paper, it looked clean, and the cleanest-looking part of it, the part their lawyer was proudest of, was the Vance water, because Cordillera's position was that the Vance right wasn't valid anymore. I'll explain it the way Della's father would have, because none of this makes sense without him, and he's the reason it ended the way it did. Her father was named Reyes Vance, and he had ridden that same ditch before Tom Edens ever did, and before that he'd spent 15 years as a clerk, and then a deputy in the state engineer's district office down in Socorro. Reyes was a waterman in the deep sense, not a lawyer, but a man who'd handled the actual paper of water rights for half his life, the filings and the priority dates and the adjudication records, and who understood that in New Mexico water runs by a doctrine called prior appropriation. First in time, first in right. The oldest right on a stream gets its full share before a single newer right gets a drop. And the date that matters, the priority date, can reach back 100 years and outrank anybody who came after, no matter how rich. Reyes taught his daughter that the priority date was everything. He taught her that the whole game in dry country was the date on the paper. He used to say the mountain doesn't care who's thirsty. It only answers to who got there first, and can prove it. He died in 2009. He left Della the ranch, and the ditch rights, and a steel file box of his own papers that she'd put in the closet, and in the way of these things mostly not opened. Cordillera's argument was technical and, on its surface, strong. They'd had a title company and their water lawyer combed the state engineer's modern records. And in those records, the Vance right showed a priority date of 1931, respectable but junior to the 1925 rights Cordillera had bought up top. Worse, Cordillera's lawyer had found that the Vance right had been listed as unexercised in a partial water rights inventory the state did in the 1980s, a clerical notation suggesting the right hadn't been actively used in some dry years. Under New Mexico law, a water right you genuinely abandon can be forfeited. Cordillera's filing argued that the Vance right was junior and partly forfeited, that the meadow's water should be reduced and the surplus moved up to the mine. The state engineer's office, understaffed and looking at a thick professional filing from a company with lawyers, was inclined to let it proceed. That's why the headgate got chained while the application was pending. Cordillera had asked for, and quietly gotten, a temporary administrative order limiting the Vance diversion. They'd done it by the book. They just expected the book to be the only book. Della Vance was 66 years old that spring. She was not a lawyer. When Tom Edens came and told her about the chain, She drove up and looked at it and didn't say much. And then she went home, and for the first time in 9 years, she opened her father's steel file box. This is the part Tom Edens watched from the edge of, and the part he made sure got written down. What Della was looking for, she didn't fully know yet. But she knew her father, and she knew Reyes Vance would not have left a steel box of water papers in a closet if it was full of nothing. She spent 3 weeks at the kitchen table going through it page by page, in her father's handwriting and older hands than his. And down near the bottom, in a folder of brittle documents her father had clearly gone to some trouble to obtain decades earlier, she found 2 things that Cordillera's expensive search had never touched, because they weren't in the modern records at all. The first was the original 1908 declaration of the Pinto Valley Ditch Association, filed when the canal was first built, naming the Vance homestead as one of the original appropriators, with a priority date not of 1931, but of 1908. The 1931 date in the modern records she'd later establish was the date of a clerical refiling after a courthouse fire, not the date the right began. The real priority reached back a generation earlier than anyone at Cordillera had imagined. It was senior to the 1925 rights they'd built their whole plan on, first in time, by 17 years. The second document was the one that mattered most, and it's the 70-year-old law in the title, and I want to be careful and plain about it. In 1947, New Mexico had conducted a formal stream adjudication on that drainage, a court proceeding authorized by state statute, in which a judge examines every claim on a stream and issues a decree that fixes each right's priority date and amount permanently. An adjudication decree is the highest, most settled form a water right can take. It is, in effect, a court order that cannot be quietly undone by an administrative notation 40 years later. Reyes Vance, in his years at the district office, had known this old 1947 adjudication existed. It had been all but forgotten, the decree filed away in a district court that had since reorganized. Never digitized, absent from the modern inventory the state and Cordillera both relied on. And he had gone and gotten a certified copy. It sat in the bottom of his steel box. It named the Vance right, it fixed its priority at 1908, and it decreed the right valid, quantified, and adjudicated, which meant, under the statute that authorized it, the right could not be deemed forfeited or junior by a later administrative inventory. The 1980s unexercised notation Cordillera was leaning on had no power against a 1947 court decree. The decree had simply been forgotten by the state, by everyone, except a dead ditch clerk who'd suspected 30 years before there was a copper company that someday somebody would need it. Della Vance read that decree at her kitchen table, and then she drove the certified copy to a water lawyer in Silver City, the only one she could afford, an old man half retired, and she put it on his desk. Tom Edens drove her because she didn't trust the road and didn't want to go alone. The lawyer read it. Tom said the old man read it twice and then took his glasses off and set them down and said very quietly that he had not seen an original 1947 adjudication decree on that drainage in his entire career and had assumed the records were lost. He said 3 words Tom never forgot. He said, "This changes everything." It did. The showdown, when it came, was an administrative hearing in a fluorescent room in Socorro, and it was over almost before it began. Cordillera's lawyer arrived with a thick file built entirely on the modern records, the 1931 date, the unexercised notation, the forfeiture argument. He'd done good work on a foundation that turned out to be sand. Della's lawyer, the old man from Silver City, didn't argue much. He didn't have to. He entered the certified 1908 declaration and the certified 1947 adjudication decree into the record and let them sit there. A 1908 priority, a standing court decree, both senior, both settled, both fatal to Cordillera's entire application. The hearing officer called a recess to read them and came back and did not come back smiling. You do not argue a 40-year-old clerical notation against a court's adjudication decree. There's nothing to say. The matter gets corrected. Cordillera's application to move the water collapsed. Not only did they fail to take a drop of the Vance water, the discovery of the true 1908 priority meant the Vance right was now senior to the 1925 rights Cordillera had spent real money buying, which threw their whole upstream consolidation into question. They'd built a plan on being the oldest right on the stream. They weren't. They'd never been. They'd just been the first to hire a lawyer to read the records that everyone had, and nobody had thought to ask whether there were older records that everyone had forgotten. The chain came off the van's headgate that summer. Tom Edens took it off himself with bolt cutters, and he kept the lock on a nail in his shed for years afterward, he said to remind himself. Della Vance still runs water onto her hay meadow off the Pinto Valley Canal, the way her family has for 110 years, on a priority date of 1908 that no one will ever question again, because it sits in a court decree now copied into every record that matters. She had her father's certified copy framed. Not the whole thing, just the first page, with the case caption and the date, 1947. It hangs in the kitchen where the steel box used to sit in the closet. She gave the original adjudication research back to the district court so it could never be lost again. Tom Edens retired from the ditch in 2021. He's the one who wrote it all down in a spiral notebook because he said somebody had to, or it would go the way these things usually go and be forgotten inside a generation. He still rides up and looks at the van's headgate sometimes, open and running. He says people think water in that country belongs to whoever's strongest or richest or got there with the most lawyers. He says he watched a 66-year-old woman beat a mining company with 2 pieces of paper a dead man had the foresight to save, and that the company never understood what hit them, because the thing that beat them wasn't newer or louder or better funded. It was older. It had been sitting in the bottom of a steel box for 9 years and in a forgotten courthouse for 70, waiting for the one person who'd bother to go looking. First in time, Reyes Vance used to say. First and right. The mountain doesn't care who's thirsty. It only answers to who got there first and kept the paper to prove it.